Hello everybody, and welcome to the first in a series of property disputes webinars which we're going to be running over the next few months. The first in the series covering today's webinar is looking at some recent case law on property disputes, and I'm joined by my colleague Stephanie Hepburn. I think there have been two major themes in the case law over the past year have been dilapidations and interpretation of contracts, so much so that those topics are going to be the subject of the two further webinars in this series. We're going to look in some more detail at dilapidations on the 24th of February in 2 weeks' time, and we're going to look at some more detail at interpretation of contracts and implied terms in the third webinar in the series on the 30th of March. But for today's purposes, we have picked out the most significant cases from the past year on those topics, and also a couple of other cases. So firstly, I'm going to take a look at dilapidations, the two dilapidations cases, Mapley Acquisition against City of Edinburgh Council and ATSIP against Insight Travel Services. I'm then going to hand over to Stephanie, who's going to look at a significant Supreme Court decision on interpretation of contracts and the principle of commercial common sense, and that's Arnold against Britain. Then going to take a look at another Supreme Court decision, Marks and Spencer against BNP Paribas Securities Services Trust, which deals with the issue of recovery of rent paid in advance after the exercise of a break option. And then finally, Stephanie is going to look at a recent case on the withholding of consent to an assignation, and which provides a useful reminder of some of the principles which apply where a landlord is considering an application for consent to an assignation. So, firstly, looking at the two dilapidations cases, and looking at Mapley first. This is a decision that was issued in March last year, and one of the issues in the case, which is also one of the issues in ATSIP, so we're going to look at the issue in both cases, but one of the issues was the question of whether the landlord was entitled to recover the costs of reinstatement of the premises after the lease had come to an end, the cost of works required to remedy the tenant's breach of its repairing obligations, regardless of whether the landlord actually intended to carry out the works. Now, the relevant wording is up on the screen there, and the obligation in question, it's the wording in bold type, the obligation on the tenant to pay to the landlord such reasonable sum as shall be certified by the landlord surveyors as being equal to the cost of carrying out such work. Now, broadly speaking, the landlord contended that this was a payment provision, that this was something which kind of overrides any claim for damages for breach of contract, and that, put simply, the landlord was entitled to payment of the costs of the works set out in the schedule of dilapidations, regardless of whether those works would be carried out. The tenant, however, argued that actually in a proper interpretation, the landlord wasn't just simply entitled to payment, and that what this was a damages provision that entitled the landlord to claim damages for breach of contract, but crucially that the landlord had to prove the loss by either stating that it had carried out the works or that it would carry out the works. Now, a crucial point in the case was the fact that the court decided that both of those interpretations were possible. The court decided that the clause was ambiguous, and that as a result it had to look to try and decide what the proper interpretation should be. Now, this was a crucial point in the case, and it's also a crucial point in the ATSIP case and Arnold against Britain, which Stephanie is going to talk about, because generally speaking, if the clause is not ambiguous, if the court decides that it's not open to more than one meaning, then the court will give effect to the words on the page. But in this case, the judge did come to the view that both of those meanings were possible. So the judge had to apply various principles that had been discussed in previous case law in looking to determine what the proper interpretation was. And in particular, the judge drew on a decision from 2014, a Scottish Appeal Court decision from 2014, which some of you may be familiar with, which is Grove Investments. And in that case, the court discussed some of the principles that apply. And that was also a dilapidations case, and we'll look at that in the next webinar in the series. And applying those principles, the judge concluded that the tenant's interpretation was to be preferred, that this was a damages provision, and that for the landlord to be able to claim the sum specified in the schedule of dilapidations, it had to be the case that the landlord had carried out or was going to carry out the works. And the four main reasons for that are up on the slide there. I mean, firstly, the judge decided that interpretation was more in keeping with commercial common sense. This is the principle of commercial common sense is a running theme in some of the case law regarding interpretation of contracts, and it's something that Stephanie's going to talk about in relation to Arnold against Britain. The judge also decided that the tenant's interpretation was more akin to the remedy which the common law would provide. What the judge said was that the landlord's interpretation would be a radical departure from what the landlord's entitlement would be at common law, and that such a departure would require to be clearly indicated in the lease, and that it wasn't in this case. The judge also decided that the tenant's interpretation was more in accordance with the fundamental purpose of the clause, which was essentially to compensate the landlord for the consequences of a breach of the tenant's repairing obligation, and also that the tenant's interpretation would be less prone to produce results which are objectively excessive or disproportionate. What the judge said was that the landlord's interpretation might result in a level of recovery which is not related to any loss which it actually sustained. So the benefit to the landlord and the corresponding burden on the tenant might be arbitrary and disproportionate and unrelated to the true significance for the landlord of the tenant's breach. So ultimately the court came to the conclusion this was a damages provision and the tenant's interpretation was to be preferred. Now, as I said, this was decided in March last year. That's when the decision was issued, and that was after the decision had been issued at first instance in ATSIP Pension Trustees against Insight Travel Services, and the outcome of ATSIP at first instance was broadly similar to the outcome in Makeley. But in December last year, the Scottish Appeal Court decision in ATSIP was issued and reversed the decision at first instance. Again, the issue in the case was whether the landlord was entitled to recover the costs of work specified in the schedule, regardless of whether or not the landlord actually intended to carry out the works. And again, the relevant wording is on the screen there. The obligation was to pay to the landlord at the termination date a sum equal to the amount required to put the leased subjects into good and substantial repair. Now, it was, I think, common ground between the parties that the parties actually agreed that the clause in question was capable of more than one meaning, and that obviously formed an important factor in the court's decision at first instance. But the appeal court took a very different view. The appeal court took the view that actually there was only one natural and ordinary meaning to be given to the clause, and that it was a payment clause, not a damages clause. And the court was quite forthright in its view, stating that to do otherwise than to give effect to what the court considered to be the only natural and ordinary meaning of the words would be to do such violence to the clause as to produce an incomprehensible result, namely that despite wording which provides only for the sum due to be measured in terms of repair costs, and despite the requirement for the landlord to elect and notify the tenant of that, that parties could be taken to have intended nothing more than that the landlord's claim be restricted to damages for breach of contract. The court said that result would, they consider, fly in the face of common sense, that word again, so as to exclude it from the possibility of being an alternative interpretation. What the court concluded was that the words on the page, the words used by the parties, clearly indicated that if the premises were not at termination in the condition in which they ought to have been, if the tenant had complied with its repairing obligations, then the landlord was entitled to payment of a sum equal to the cost of doing that, and whether or not the landlord intended to carry out those works was irrelevant. Again, there was some brief discussion about grove investments, and what the court commented that care must be taken to avoid reading anything said in grove as being to the effect that the court can correct a bad bargain or even an unfair one. There is no general rule that a commercial contract requires to be fair. The judge then referred to a comment by one of the judges in Arnold against Britain, which was that it's not legitimate for the court to rewrite parties' agreement because it was unwise of one party to gamble on future outcomes. The question for the court is not whether a reasonable tenant would have entered into the obligation. The court also noted that the observations made in Grove Investments, which, as I mentioned earlier, was a decision issued in 2014, predated the guidance provided by the Supreme Court in Arnold against Britain, and so must be regarded with an appropriate degree of caution. So I think it was of some significance in ATSIP that it followed on from the decision in Arnold against Britain. Mapley, of course, predated the decision in Arnold against Britain, and like Grove, possibly should be regarded with a degree of caution. Cases like these will always turn very much on the precise wording that's used in the lease, but I think ATSIP can give some comfort to landlords that if they have a clause like this, that I think following on from Arnold against Britain and the appeal court decision in ATSIP, that they might have a better chance than they would have done prior to that of persuading a court there is a payment provision. I'm now going to hand over to Stephanie, who's going to talk a bit more about Arnold against Britain.
Thanks, Dan. Well, continuing with the theme of contractual interpretation, I'm going to talk about the case of Arnold against Britain, which is another interpretation case, this time not on dilapidations, pleased to hear, but regarding the service charge provision in the lease. It's an important judgment, particularly in the application, as Dan said, of this commercial common sense. The facts are quite unique, so it's just worth having a mention of what the facts are. Mrs Arnold owns Oxwich Leisure Park, which contained, I think, 90-odd modest holiday chalets. Each of the chalets is let for a period of 99 years from 1974, all on similar terms. And for 25 of those chalets, the service charge is reviewed every year. The service charge provision is on the slide there, and it was to pay the yearly sum of £90 and value-added tax, if any, for the first year of the term, hereby granted, increasing thereafter by £10 per 100 for every subsequent year or part thereof. The effect of this annual 10% compound interest provision would put the service charge for these pretty modest holiday chalets at over £500,000 by the time the lease ended in 2072. The issue between the parties then was whether the figure of £90 as inflated should be read as a fixed amount, which would mean the tenants were obliged to pay a sum increasing at a compound rate of 10% a year, regardless of the costs to Mrs Arnold of providing the services, or whether we could read that service charge provision as having an upper limit or some sort of cap, which meant the tenant was only obliged to pay a proportion of the cost of providing the service charge up to a cap of 10% on increases. And the court said the answer to that question depended on if you could read into the service charge provision such words as limited to or up to before the reference to £90. At first instance, the tenants were successful, and the court said the purpose of the clause was to allow the landlord to recover the costs, but not to make a profit. The tenants then lost on appeal both to the High Court and the Court of Appeal, and these courts found that as a matter of language, the words that used the service charge provision were a strong indication that a fixed sum was due. And the court said that if it had found for the tenants, it would have involved subverting the proper process of construction of the language actually used, and would in truth involve the court rewriting the bargain the parties had made at the time of contracting. The tenants then appealed to the Supreme Court. And I think that the task before the Supreme Court was really to apply canons of construction in circumstances where the outcome of a literal approach to the construction would produce What the tenants said was a perverse result. At the end of the lease, they'd have to pay, depending on the variation of the clause applied, millions of pounds in service charges when the actual expenditure on the service charge could be as little as nil in any given year. The courts must identify the intention of the parties by reference to what a reasonable person having the background knowledge available to the parties at the time they contracted would have understood them to be, using the language in the contract. What this meant was that the meaning of the words had to be assessed in light of the 5 points on the slide there. The first was the natural and ordinary meaning of the clause. Second, any other relevant provisions of the contract. Third, the overall purpose of the clause and the contract. Fourth, the facts and circumstances known or assumed by the parties at the time they contracted. And lastly, those words again, commercial common sense. The Supreme Court dismissed the tenants' appeal by a majority of 4-1, and it held that the natural meaning of the clause was clear, and a reasonable reader of the clause would have understood that the first part of the clause, and if we go back to the clause, the first part was to pay the yearly sum of £90 and VAT, if any, for the first year of the term hereby granted. The court said that a reasonable person would have understood that part of the clause to require the tenants to pay an annual service charge to reimburse the landlords for providing the service. And it wasn't until you got to the second part of the clause, which said increasing thereafter by £10 per hundred for every subsequent year or part thereof, that the court said it was that second part of the clause that identified how the service charge was to be calculated, which was a fixed sum with a fixed 10% annual increase. And it was only once the commercial effect of that interpretation played out that concerns arose. The court said that the importance of on the language of the provision should not be undervalued by relying on this commercial common sense concept. The court was quite clear that commercial common sense is not relevant where the natural meaning of the language is clear, and the court was of the view that in this case the wording was pretty clear. The court also said that commercial common sense cannot be invoked retrospectively to events arising after the date of the contract, and it's only that commercial common sense is only relevant to ascertain matters at the time of the contract. And the court was of the view that the concerns regarding the level of service charge and this increasing to the millions of pounds in the future only arose some years after the lease was entered into. This case was, I think, about 20-odd years after the lease was entered into, maybe even more, 30 years. And the court said that it was only after the event that when the commercial effect of compound interest became apparent, that the commercial common sense interpretation really became part of the argument. And the court said it was only relevant to look at commercial common sense when you're looking at matters at the time of the contract and not those that arose years later. And the third point that the court, touching on what Dan said about the ATSIP case, the court said that just because an agreement works out badly for one party, that doesn't justify departing from the natural meaning of the language used. It's not the court's function, they said, to relieve a party from the consequences of imprudence or of bad advice. The mere fact that a court might be confident that the effect of or consequence of a particular clause or interpretation later in the day was not intended by the parties did not justify rejecting that interpretation. So what's the main message from this case then? I think what I would encourage parties to take from this case is when you're drafting contracts, say what you mean and mean what you say, and perhaps avoid compound interest provisions like the plague. The real significance is probably the court's concise and comprehensive distillation of the principles involved in the application of commercial common sense, and that's quite interesting and where we really see more of a shift towards contractual certainty. I think the more direct effect of the judgment is probably more limited. I think it was Lord Neuberger who said in the case that whatever interpretation is correct, the clause was self-evidently not a normal service charge provision, and it's unlikely there's going to be a number of tenants battling with similar provisions in the leases elsewhere. In case any of you were sparing a thought for the poor tenants and the resulting service charge liabilities, a press statement on behalf of the landlord after the judgment had been handed down did say she's prepared to consider some sort of renegotiation having regard to the calculation of service charges in the long term, which perhaps goes some way to achieving the happy ending that was sought by the tenants. I'll now head back to Dan, who will talk about the Marks and Spencer's case.
Thanks, Stephanie. Yeah, this was another significant Supreme Court decision issued last year, and the issue in the case was whether the tenant, Marks and Spencer, could recover a proportion of quarterly rent which had been paid in advance in circumstances where a break date occurred between the quarterly rent payment dates. Now, broadly speaking, the circumstances were that in terms of the lease, the case actually involved 4 leases, but they were substantially the same. So the judgment, it was appropriate to simply look at one of the leases. The rent was to be paid yearly and proportionately for any part of a year by equal quarterly instalments in advance on the usual quarter days, fairly standard wording. There was a break right in favour of the tenant, which was exercised by giving 6 months prior written notice to take effect on the 24th of January 2012. What the break clause provided that it would only take effect if there was no rent outstanding, and also if a break premium was paid to the landlord by break date. So, rent, the break notice was served 6 months prior to the break date. Rent was then paid as usual on the 25th of December for the quarter ending 24th March 2012. The break premium was paid to the landlord on the 18th of January 2012, and that satisfied the conditions of the break clause and meant that the lease terminated on the 24th of January 2012. The tenant then sought repayment of the proportion of rent for the period from the 24th of January to the 24th of March. On the basis of an implied term, the tenant accepted that there was no express provision for this in the lease, but on the basis of an implied term that if the tenant exercised the break option and the lease consequently terminated on the 24th of January, that the landlords ought to pay back a proportion of the rent paid for that period. Now, the tenant won at first instance, and I think it's fair to say that that caused a bit of surprise amongst practitioners who had always understood that a tenant, that in the absence of an express provision, the tenant would not generally be entitled to reimbursement of a proportion of rent in those circumstances. The landlord appealed and was successful in the Court of Appeal, and the tenant then appealed to the Supreme Court. The Supreme Court's decision is useful in that it provides some helpful guidance on the principles which apply in relation to when looking to whether or not to imply a term into the contract. And I won't talk about those today. We'll cover that in the third webinar in the series on the 30th of March. But for present purposes and applying those principles, the court obviously looked at whether or not the implied term intended for by the tenant should be implied into the lease in question. Now, the court did comment that the proposed implied term would be fair. The court did take the view that the lease could be said to work unfairly without it. In fact, the court said there's real force in the contention that if the landlord could retain the apportioned sum, it would be unfairly prejudicial to the tenant and a pure windfall for the landlords. A provision that the landlord should reimburse the tenant the apportioned sum would, on that basis, seem to be reasonable and equitable. The court also pointed out that it was common ground between the parties that because the tenant hadn't paid the break premium before the rent payment date of the 25th of December, it wouldn't have been known as at that date whether the lease was going to be coming to an end, and that because the premium hadn't been paid, the tenant did have to pay the quarter's rent in full. It only became clear that the lease would terminate when the break premium was paid on the 18th of January. But the tenant argued that if they had paid the break premium before the rent payment date, that it would have then been open to them to simply pay a proportion of rent up to the 24th of January. And the court agreed with that and took the view that, again, on that basis, the tenant was contending that commercial common sense, that concept again, would mandate that it should be in the same financial position whether it pays the break premium before the rent payment date or whether it chooses to wait, as it was entitled to and as it did, until after the rent payment date to pay the sum. But that, unfortunately, did not sway the court, nor did the fact that the court did consider that the proposed implied term would be fair, because there were countervailing considerations, and a main one was the fact that, as the court commented, the lease was a very full and carefully considered contract, prepared by professional advisors and containing express obligations like the proposed implied term. The court said that there's force in the argument that the payment provisions relating to the break showed that the parties had directed their minds to the specific question of what payments were to be made between them in connection with the break, and in particular what sums were to be paid if the right to break either was implemented or was not implemented, and that renders it inappropriate for the court to step in and fill what is no more than an arguable lacuna. The court commented that the lease is a very full and carefully considered contract, which includes express obligations of the same nature as the proposed implied term, namely financial liabilities in connection with the tenant's right to break, and that the implied term would lie somewhat uneasily with those provisions. But more significantly, the court noted that at common law, the position was that rent is not that rent payable in advance is not apportionable, and the court said that that was the backcloth against which the terms of the lease had been agreed. And what the court said was that, save in a very clear case indeed, it would be wrong to attribute to a landlord and a tenant, particularly when they've entered into a full and professionally drafted lease, an intention that the tenant should receive an apportioned part of the rent payable and paid in advance, when the non-apportionability of such rent has been so long and clearly established in the case law. Given that it's so clear that the effect of the case law is that rent payable and paid in advance can be retained by the landlord, the court said that express words would be needed before it would be right to imply a term to the contrary. So the result was that the term could not be implied and that the express term would have been needed for repayment. I'm now going to hand back to Stephanie, who's going to talk briefly about Homebase against Grantchester Developments. And I should say that if anyone has any questions, please pop them into the chat facility, and we'll hopefully have a chance to answer one or two of them at the end.
Okay, so moving away from those wretched contractual interpretation cases, we thought we'd finish just quickly going over the case of Homebase against Grantchester Developments, which is a good old consent to assignation case. And the question is really just how much information can a landlord demand from a tenant when it wants to assign its lease. And I think following this case, the answer may well be more than you might think. In this case, Homebase was the tenant and they wished to assign their 25-year lease but required Grantchester's consent. The clause has standard wording as you would expect in an FRI lease. The wording is on the slide there. Nothing unusual, exactly what we see every day in normal leases. The landlord requested further details of a proposed transaction between Homebase and the assignee, so it could assess any impact that the transaction may have on the landlord's interest in terms of the lease. The landlord asked specifically for any information on reverse premiums or financial arrangements that may relate to any payments that the assignee would pay following the assignation. Homebase claimed this was irrelevant and the landlord should only be concerned with the identity and character of the proposed assignee and its ability to comply with the current tenant's obligations under the lease. Homebase refused to provide the information and so Grantchester did not provide its consent. And the court held that the landlord had not acted unreasonably. What the court said is the clause in the lease that required consent was a two-stage test, and the first stage involved assessing if the proposed assignee was of sound financial standing and therefore met the financial test set out in the lease, which must be made on an objective basis, and if the proposed assignee fails to meet this test, the landlord has an absolute right to withhold consent. It's only if, as it was here, the proposed assignee does meet the financial test that you pass to the second stage of the test, which allows the landlord to withhold consent if it's reasonable to do so. There's often good reasons that are not connected to the financial standing of the proposed assignee that require a landlord to say they're withholding consent, although, as we know from previous cases, the landlord can't do this if the reasons are not connected to the landlord-tenant relationship. And the question in this case was whether the requesting of the information about a rent subsidy or reverse premium paid to Homebase by the proposed assignee was reasonable. And the court said that because the payment of a rent subsidy or reverse premium could impact on the rental value of the property or any future rent reviews, for example, the request was reasonable, and Homebase's refusal to provide it gave good grounds to withhold consent. The judgment follows the authorities we've had previously from the Burger King cases, for example, and makes clear that because the payment of a rent subsidy or reverse premium is a matter which might have an effect on the rental value in the future, then the nature of any reverse premium or rent subsidy may offer reasonable grounds for refusing consent. The court placed emphasis on the word might, which is quite interesting, and what the court said is even if the payment of a rent subsidy or a reverse premium is a matter which only might affect the landlord's consent to the proposed assignation, it still follows that it's reasonable for the landlord to require the information to be supplied before it makes its decision. The case provides reassurance for landlords, I think. It protects them from unfavourable assignations, so long as the reason for not giving the consent relates to the landlord-tenant relationship. Tenants should expect to provide full information to landlords about proposed assignees, and hefty reverse premiums or similar incentives could increase the risk of the landlord simply not giving the consent, and that's worth bearing in mind in negotiations. The case might provide useful for landlords who wish to have information about inducements by their tenants, but perhaps not so welcome for tenants who want to keep this information confidential. And I pass back to Dan to conclude the webinar.
Thanks, Stephanie. As I said, if anybody do have any questions, please pop them into the chat facility. We'll answer one or two if we can. If anyone's interested in looking at the judgments in these cases, the citations are up on the screen there, and you will receive copies of the slides by email following the webinar. Doesn't seem to be any questions coming through, but what I will say is that well, there's
I'll pick up on that comment.
One comment has come through from one of the participants about doing worked examples before agreeing formula.
Yeah, I think this is in relation to the Arnold against Britain point. I think it's absolutely right. The query that's been raised is if you're negotiating a lease and drafting a lease, do worked examples before you agree the formula for your service charge, which absolutely is a practical solution to what happened in Arnold against Britain. Obviously, we haven't seen the lease in this case, and I had a quick look at the case there. It doesn't actually say if there are solicitors involved in the drafting of the lease or not. As Dan touched upon the Marks and Spencer's case, the court in that said, the court was quite quick to say this lease was one prepared by solicitors. It was quite a hefty lease that had quite strict provisions in it. I don't know about the lease in this particular case, but yeah, worked examples could provide a practical solution to the problem that arose.
So there's no questions have come through. If anyone does, after the webinar, have any questions, then please do feel free to get in touch with either me or Stephanie. Our contact details are on the screen, and we'll also be provided by email following the webinar. So thanks for joining us today. I hope you can join us for the next webinars in the series. As I say, the next one looking at some more detail at the recent dilapidations case law. That webinar is on the 24th of February, and then the third webinar in the series is looking more closely at interpretation of property contract and implied terms, and that's on the 30th of March. I hope you can join us for those. Thanks for joining today. See you later. Bye.